With over 21 million inhabitants, the Mexico City Metropolitan Area is a bustling region with enormous urban challenges, access to water being no exception. Despite its notoriously long rainy season, the city faces supply gaps in many low-income and working-class neighborhoods due to crumbling infrastructure, enormous population demands, and its own hostile geology. Among the many problems facing the region's water supply, one case in the south of the city has exposed how shallow aquifers are ecologically at risk of decimation by the city's under-restrained development. This case involves a land developer known as Quiero Casa, who is currently constructing an apartment complex in the original Village of Los Reyes in the Borough of Coyoacán. When completed, the project known as Aztecas 215, or formerly Proyecto Cantera, will consist of 3 8-story towers with 377 apartment units. In early 2016, excavation began on the site in order to construct 3 levels of underground parking. Within the first few digs, water flourished from the ground and flooded the site. In order to mitigate the flooding, Quiero Casa diverted the water via tubes directly into the municipal drainage system without any authorization to do so. Neighbors took notice and began to protest. Since then, there have been demonstrations, filed complaints, litigation attempts, stakeholder meetings, and many other measures to address neighborhood concerns over the drained water. To date, none have been successful. The water is not merely of symbolic or abstract value to the surrounding neighborhoods. Many local residents rely on informal and unregistered wells to tap into the shallow subsurface waters for non-consumption household purposes, such as washing clothes, cleaning the home, or flushing the toilet. While the neighborhoods have known about the shallow water's presence for many years, it has never been formally recognized or regulated by government authorities. Now, legally, the status of the water remains convoluted and unclear. The Mexican Constitution recognizes the right of landowners to artificially extract subsurface waters, but it also asserts the public's interest in protecting this water and instructs the government to regulate the extractions accordingly. Further, the geologic nature of the shallow subsurface water continues to be in dispute. In the case of Aztecas 215, neighbors and ecologists at the National Autonomous University of Mexico, UNAM, have argued that the water is a moving aquifer of potentially usable water that flows through the area from the Chitle Mountains further south of the city. On the flip argument, Quiero Casa and geologists at the same university, UNAM, have argued that the water is a discharge that is too contaminated for any immediate household use. The government has yet to reach any formal conclusions or recognitions of this water. Mexico City's civil code prohibits landowners from diverting water in a manner that causes harm to third parties, such as the neighbors. It also mandates that water extractions be in accordance with local codes and regulations. Unfortunately, there is no law that outright prohibits the drainage of aquifer or other shallow subsurface waters. In fact, Quiero Casa did not technically break the law when it drained the subsurface water. Instead, any potential legal problems arose in the form of irregularities in Quiero Casa's permitting applications and with the lack of adequate oversight and regulation by the appropriate government authorities. Here, Quiero Casa claimed that the water table was not found in the shallow subsurface when it submitted an environmental study to local authorities for permitting purposes before construction began. This was clearly untrue due to the immense flooding that occurred once construction was underway. By either fabricating data in its permit applications or by failing to apply due diligence in filling out such documents, Quiero Casa failed to fulfill its obligations when it legally obtained permission to build underground. Neighbors organized with volunteer attorneys to file several lawsuits in defense of 2 general rights: the right to the environment and the right to access to water. Unfortunately, due to standing and other procedural requirements, the neighbors have not gotten fair access to the courts. Neighbors also filed complaints with various local agencies, and they continue to have meetings with authorities to seek redress for the damages caused by Quiero Casa's actions. Some agencies have been non-responsive to the complaints. Others have issued suspensions or sanctions on Quiero Casa, but have failed to follow through with compliance and supervision. For example, in early 2019, when Quiero Casa's construction permits were suspended, the developer removed the suspension seals from the site and continued construction. Despite being an overtly illegal and criminal act, Quiero Casa walked away with impunity as government officials failed to effectively suspend the works. Eventually, Quiero Casa regained formal permission to continue construction. Unfortunately, the unauthorized and underregulated drainage of shallow subsurface waters is a problem that is taking place all across Mexico City. Yet it is rarely discussed, nor is it fully scrutinized. Further, the blame does not fall entirely with the developers. A faulty regulatory system often forces developers to choose between absolute compliance that is slower, costlier, and sometimes silent, versus cutting corners to efficiently complete their projects. When the government agencies fail to step up to fulfill their mandates, this leaves developers with that latter option. In order to begin addressing this problem, there are a few key legal, political, and judicial reforms that must take place. First, federal and local agencies need to legally recognize the shallow subsurface waters across the city. Second, the drainage of shallow subsurface waters needs laws and regulations to mitigate such behaviors in developments and other construction projects. Third, government agencies must be proactive in investigating irregularities on construction sites and, further, must be fully responsive to citizen reports and complaints. Fourth, developers should be held accountable for any illicit acts. They must not fabricate or misrepresent information in their permit applications and other forms before government agencies, and they should be held accountable when they do. Criminal penalties for the removal of suspension seals must be enforced. They must actually comply with the universal regulations and any individual resolutions that are tailored for them. Finally, the legally recognized human right to access to water needs to be litigated in the courts in order to establish a judicial framework for resolving conflicts under the Mexican legal system. In order to fully flesh out the constitutional right to water, there needs to be more strategic legislation that can help create a robust jurisprudence by the courts. Protecting the shallow subsurface waters of Mexico City is integral to mitigating the region's water crisis. This will require the coordination of stakeholders such as government officials, citizen activists, and developers, as well as experts such as engineers, geologists, ecologists, and lawyers to create a functioning system that advances the public good. This is a fixable problem. It just requires the will to get it done.